But first, courtroom closed. There have been some new motions filed in the case of Stephan Sterns. He is accused of raping and murdering 13-year-old Maddie Soto. His legal team now asking the judge to ban the public and the press from pretrial hearings in the sexual battery case. This is slated to go to trial in May. The motion filed by his attorney says that the spread of information that's going to be presented in these hearings could or would prevent a fair trial. Joining us live now via Zoom to talk about this is Belvin Perry, a former chief judge of the 9th Judicial Circuit. And Judge Perry, we appreciate you joining us this morning here on Fox 35 News Plus.
Great to be here with you today.
I first want to get your reaction to this motion, and first just kind of talk to us about, is this a common step in a case like this for an attorney to make this ask?
Yes, it's a common step, but closing a courtroom in a criminal case occurs very limitedly, and it's usually involving cases where there is a potential for witness intimidation, where there is a child victim who's testifying. So in order to close this case, they must look at a very high bar, which I don't think the defense is going to be able to do this because there is an alternative to closing this courtroom.
So talk us through some of the factors here, because obviously we live in a society that has these public trials and public hearings. Courtrooms typically open. So walk us through kind of what would be considered in deciding whether or not to grant this motion.
First, there must be some substantial interests at stake. In this particular case, they're talking about pretrial publicity, that the defendant cannot receive a fair trial. They must show that closure is necessary to protect that particular interest. But there are alternatives to closing the courtroom. One is jury selection. The jury can be questioned separately as to the effect of pretrial publicity. The court can review the evidence and determine which evidence should be disclosed publicly and which evidence should not. In this particular case, just like the Case Anthony case, which had extensive pretrial publicity, you can get a jury. I doubt very seriously if the court is going to close the courtroom.
Let's talk a little bit about that. You mentioned the alternatives and kind of the alternatives to closure that would have to be considered and found inadequate. What you mentioned, kind of some of the evidence that would not be presented publicly. What would that kind of entail? What would that look like?
Let me give you a classic example. Let's say this particular case, the actual homicide was recorded on videotape and was very graphic. The court could close that publication to the news media so that they could not actually broadcast it live during the trial. They could close that to the news media at a pretrial hearing and instruct the news media not to record that. That would be the classic example. But this is just a boilerplate motion that they have filed to dot the I's and cross the T's, because you're looking at the First and Sixth Amendment to the Constitution, which guarantees the press access and the public access to the trial. And doing this would basically start what I call a star chamber proceeding.
What do you mean by that?
Star chamber proceeding is where there's no public, there's no one there but the defendant and the attorneys. There was a movie called The Star Chamber where people decided people were guilty, and then they went out on their own and executed punishment.
And why is, you mentioned the Constitution, the amendments to the Constitution, and kind of the role that plays in keeping these courtrooms open. Why is that such an important thing to have courtrooms open to the public and to the press?
Because when you look at the old history coming from England, there were court proceedings that were closed. This relates to the integrity of the system. You cannot have a system that is closed because people will question the fairness. That's why the courts are open, so that eye of the public and the media will be there to make sure that justice is actually followed and not some starry concept that's done in the behind closed doors.
At the same time, this is a case that has gotten a lot of attention. What do you think the search for a jury will look like when this case does go to trial, and kind of the difficulties and the process there for finding an impartial jury?
The court will at first try to see the jury in Osceola County unless both the state and the defense agree that it needs to be moved. The court has the alternative, just like I did in the case of Anthony case, of going to another location and pick a jury and bring that jury back to Osceola County and let that jury hear the case. The question is not whether or not someone has heard pre-trial publicity, is whether or not they have formed an opinion about the guilt of the defendant and whether or not they could set aside that opinion. If they say they can set aside whatever opinion that they have formed in this case, then they are qualified to serve on that particular jury.
I would imagine a motion like this was filed in the Casey Anthony case. Can you kind of walk us through, if you remember, what your thinking was like in seeing that and responding to it?
Well, number one, they did not file a motion to close the courtroom at all. What they did was file a motion for change of venue, and due to the nature, that motion was granted because of the extensive pretrial publicity, which caused us to go to Pinellas County to select a jury, which took us 2 weeks to do, and to bring that jury back to Orange County for the trial of the case.
What, I know you said this is kind of just a boilerplate motion, something that the defense, it seems, is just kind of doing to make sure they do everything they can. It certainly doesn't sound like it's something that you expect to happen. But what sort of situations would we see something like this be granted?
As I said before, if there was a closing the courtroom, if there was a child victim of a sexual battery, you could close the courtroom then. If you are talking about sensitive information like national security, you can close a courtroom. If you have a confidential informant, you could close a courtroom. Those are the limited situations where you could have a courtroom closed to the public and to the media.
A pretty high bar, though, it sounds like, from what you're saying, for something like this to be granted.
It's an extremely high bar, but the defense must do this because if they don't, you can believe that if this defendant is convicted, his lawyers on appeal will raise this and say that his counsel was incompetent for not filing this particular motion. So it's one of those things that they must file to perfect the record to show that they did everything that was possible to make sure he had a fair trial.
All right. Belvin Perry, the former chief judge for the 9th Judicial Circuit. Always appreciate you joining us here. You're a wealth of knowledge, and we appreciate your expertise. And thanks for joining us this morning here on Fox 35 News Plus.
Thank you.